This is an appeal in the matter of Orji and another and Nagra and another.
Thank you very much. Mr. Strafford, just before we start, can I say that, as you would imagine, the court's read the papers, read what we think are the relevant authorities, so we have a lively appreciation of the issues. That's not said so that I terrorise you into only being 20 minutes, but just so that you know what the court has read and the position that the court's in. So take your own course, but some of the background stuff you can take it, we know.
I'm grateful for that, my lord. I of course represent the appellants, my learned friend Mr. Coulson, the respondents. As the court knows, this is an appeal against the order of His Honour Judge Berkley on the 14th of September 2022, refusing an appeal against the decision of Deputy District Judge Payne, striking out the claimants' action against the respondents, the defendants, for malicious prosecution as an abusive process of the court. And this second appeal is brought with the permission of Lord Justice Warby in January of this year, and that is at page 67 of the core bundle. My lords, the primary issue on this appeal, says the appellants, is it is of course an abuse to litigate a matter which could and should have been determined in earlier proceedings, and that's known as the rule in Henderson and Henderson. What we say is that that rule doesn't extend to matters which have not and could not have already been decided, and that's the facts of this particular case. As my lords will have appreciated, from looking at the papers in this case, matters arise out of altercations which occurred between the claimants and the defendants on the 25th and 26th of March 2018. It's not necessary for me to rehearse the various versions of that. Suffice to say, allegation and counter allegation of assault are made. But what then happens is that a claim is issued for trespass to person and trespass to goods by the claimants in this action, malicious prosecution action, against the defendants in the malicious prosecution action, and indeed two other defendants who were later joined. I did, my lord, want to take the court to the pleadings, because one of the issues, as the court will appreciate, is that there have been different versions of the particulars of claim, and I wanted to take the court to those. So the first version in time is that which appears of the trespass claim, I should say, is that which appears at page 6 of the supplementary bundle. And this was the claim that was issued by the claimants in April 2018. The court will see from the claim form, as I say, a claim for trespass to the person, trespass to property, a value given of £50,000, and then brief particulars given on the back of the claim form. So that, my lords, is version 1.
So that's the claim form, and that's dated, what did you say?
The issue date is 5th of April 2018. I don't think there's another date on it.
No, I've got that. Okay, so that's a claim form with rather than with an attached particulars claim, with particulars claim on the second page.
Yes. So, my lord, going through what then happens, the first hearing is before Deputy District Judge Alexandri, and that's in November of 2018, so about 7 months after the claim was issued, and his order is at page 9 of the same bundle, the supplementary bundle. and it suffices to say what happens at that hearing is he gives the claimants permission to make amendments to the parties, and at paragraph 7 of his order gives the claimants permission to apply to, he says, further amend his claim.
But that's by adding claimants and parties rather than to the substance of the claim.
My Lord, the paragraphs 1 to 3 are adding parties, adding or substituting parties. And then there's a slight curiosity because paragraph 4 says amended claim form to be sent to the court by the 28th of November. But when you look at paragraph 8, paragraph 4 above is discharged. So what we're left with is paragraph 7, which effectively is giving claimants permission to...
That's not what it says. It says claimant to apply for permission.
I'm sorry.
By 21st November. So what he's doing is he's saying you've got another 2 weeks, because this is made on the 7th of November, if you want to apply to further amend. And if you do, then paragraph 4 will be discharged. That's how I read it.
My Lord is quite right. My Lord is quite right. That application was in fact made and indeed granted, and we see that from the next page, page 10 of the supplementary bundle, and it was granted by District Judge Sparrow at a hearing on the 27th of December, so about a month and a half later. And paragraph 5 of District Judge Sparrow gives permission to the claimants to amend the claim form and particulars of claim in the version dated the 7th of November 2018. And we have that version, my lords.
Is that page 35?
Page 30, 28 is the claim form, 30 is the particulars of claim. So this, and you'll see, my lord, from page 32, the writing's a little hard to decipher, but this is the 7/11/18 version of the particulars of claim. So this is version 2. And this is the version that District Judge Sparrow gave permission for. So at this stage, this is, as it were, the official version of the claim.
Starting at page 30.
Starting at page 30, my lord, yes. So at this stage, it is still limited to a claim in trespass to person, trespass to goods, but it's detailed in more particularity than the version which was on the back of the original claim form. Page 33 claim form, page 35 particulars of claim form is in fact version 3. And this is dated, you'll see from page 38, the 7th of January 2019. The point, however, to make about version 3, and I think this is common ground, is that it doesn't appear that the court ever gave permission for version 3. Indeed,
There was an application though, because the judge refers to it and says, I didn't see it until after I'd heard the hearing.
that's version either 4 or 5.
Is it?
Yes.
That was the version that included the malicious prosecution.
Yes. So that's version 4.
Okay, so no, that's right. That's 2020.
That's, yes.
Okay,
Yeah.
thank you. My mistake.
So this is
It's not issued, is it? The claim form.
It's not stamped as being issued. I'm not aware that there was any formal application, and certainly there's no order of the court giving permission for this version. And in fact, what we'll see very shortly happens is when the matter next substantively comes before the court, Deputy District Judge Collins, he says the official version is the 7/11/18 version. That's what I described as version 2. So in effect, version 3 exists, but it was certainly never formally before the court. And I was just departing from the procedural history of the civil claim to interject it's at this point or shortly after, on the 30th of January 2019, that the claimants are convicted of a number of offences in the Southampton Magistrates Court.
Yeah.
The first claimant convicted of 5 offences relating to matters on 25th and 26th of March. The second claimant convicted of 7 matters solely relating to the 26th of March. The short point to make about those is that, save for an offence of obstructing a police constable, for which the second claimant stood convicted, all the convictions rely on evidence given by the defendants in the trespass claim. I ought to mention the order of District Judge Taylor on the 15th of April 2019. That's at page 13 of the same bundle, the supplementary bundle. And I mention it because criticism is made of the number of applications made by the claimants, and it's right to say that this was an application made by the claimants which was not successful. It was an application for specific disclosure, and just as it were taking stock at this stage. So by this stage of the proceedings, which is about a year after they were first issued, the claimants have made 2 applications. One was Deputy District Judge Alexander adding and substituting parties. The next one was District Judge Sparrow, and that's version 2 of the claim form. So both of those applications successful. And then this third application dealt with in April 19, unsuccessful, and visited with an adverse costs order. The defendants then make an application to strike out the whole of the claim, put briefly on the basis that, well, you've been convicted at the Magistrates Court, so there can be nothing in your claim. That was dealt with by Deputy District Judge Collins on the 6th of August 2019, and his order is at page 72 of the supplementary bundle.
'72.
72, my lord. So defendant's application was to strike out the whole of the claim. It was successful, we see from paragraph 1 of the order, to the extent that 5 out of the 15 paragraphs of the claim were struck out. And putting it briefly, those were the claim for harassment, that's paragraph 4, and the claim for trespass to goods, that's paragraphs 11, 13, 14 and 15.
No, it's paragraph 3, not 4.
I'm sorry, paragraph 3.
What was the basis for striking out the claim to trespass to goods?
My lord, there is no transcript of that hearing, but my understanding is it was on the basis of that it was inadequately pleaded.
And this is the version on page 30 that was being attacked.
This is the version on page 30, the November 18 version. So version 2, and Deputy District Judge Collins, as it were, accepted that was the latest quote-unquote official version.
So that doesn't seem to be connected to the fact of the convictions. You told us that the defendants applied to strike out the whole claim on the basis that the claimants had been convicted.
Yes,
But actually, these individual paragraphs, as in answer to my lord, that one failed because of how it was pleaded. So not because there'd been conviction.
my lord, that's my understanding, yes.
Well, I mean, that would seem to make sense.
He reserves the position on 7, 8, 9 and 10,
Yes,
which are the pleaded allegations that the defendants assaulted the claimants. And he says if your conviction is dismissed, or your appeal against conviction is dismissed,
yes,
then the court will consider striking them out too.
my lord, yes,
And that's paragraph 2.
my lord, yes.
Yeah.
Now,
Can you give, so this is between conviction.
So this is between,
So what were the dates again of dates of conviction?
so 30th of January 2019, conviction in the magistrates.
Yes.
Sentence a month later. Of course, the appeal can't be issued until after sentence. As soon as sentence, appeal was issued, and then appeal was dealt with in the Crown Court over a number of days, starting in September 19, but concluding on the 23rd of December.
Thank you.
And the other application that had been made by the defendants in April of 19, as well as striking out, was to enter judgment in default for them on their counterclaim. And what Deputy District Judge Collins says about that is at paragraph 3, the defendant is likely to enter judgment on the counterclaim, and then lists a case management conference on the 13th of January. So in effect, to deal with what happens after the result of the Crown Court appeal is known, and also the application for default judgment on the
So
counterclaim.
is the word likely a misspeak, or is it, what's it mean?
Yeah, I think it's a misspeak.
What should it be?
I
Entitled?
interpret
At
it.
liberty to.
I interpret it as we're not going to decide that now. We're going to decide that later, and that's why the case management hearing was listed for January.
Okay.
Oh, so it doesn't mean the defendant is today entitled to enter. It means it's going to be something to be decided in the future.
That's how I interpret it, my lord, yes.
We haven't seen the counterclaim. What was the counterclaim for? Cross assault?
Rent.
Arrears of rent.
My lord, I'm sure I can find it. It's page 48.
Thank you. And I think there had in fact been a defence, but for the counterclaim that the district judge wasn't aware of it. Right?
The position is that the defence was late, and so the defendants took the view, well, you're
You're in default.
you're
Therefore,
in default,
I see.
but that's not in fact the way the rules are interpreted. If a defence is issued before the court enters judgment, then the court can't enter judgment in default, no matter how late you are with your defence to counterclaim or your defence.
So the defence was late, but before judgment was entered.
Yes. And that will cause us some issues which we'll see in a moment.
The counterclaim is for arrears of rent over and above those for which judgment has already been obtained.
Yes,
And damages for effectively damage to property.
yes.
Yes, thank you.
So that does indeed bring us to the, I've mentioned the Crown Court appeal. It's strictly, if I'm dealing with matters in chronological order, I should say that as this court will be aware, that all the convictions were overturned save for the conviction against the second claimant for obstructing a police constable. That conviction rested on the evidence of an officer, which was accepted by the Crown Court. What the Crown Court found was that the evidence of the Nagras was unsatisfactory in a number of ways, and the Crown Court did not consider that they gave reliable accounts of what had happened on the 25th of March. The Crown Court was rather left with the impression it was the Nagras who were the aggressors, and was also critical of self-selecting video evidence. And on that basis, the Crown Court, as I say, overturned all the convictions, save for the one that relied on the evidence of a police officer.
Presumably, since the issue was whether they were sure that the convictions were safe, they don't decide whose version is the true version. They just decide that the evidence wasn't sufficient to satisfy them beyond reasonable doubt.
Yes.
It's a rehearing. An
It's
appeal,
a re-
an
it's a
appeal
rehear-
against conviction to the Crown Court
Yes,
is a
yes,
rehearing,
It's a rehearing.
with the burden of proof again being on the prosecution.
Yes.
Yes.
The theft charges, the theft of tool charges, one against each claimant, didn't get past half time. The others got past half time, but as my lord rightly observes, the effect of the finding is the prosecution case didn't reach the necessary standard of proof.
But we've got a judgment from Recorder Pilfer's-Gorster, is he called?
Pilgerstorfer, yes.
Yes.
We've
Sorry,
got a
sorry.
written judgment from Mr. Recorder Pilgerstorfer and the magistrate who he sat with, yes.
Yeah.
Thank you.
So, my lords, that does bring us then.
So that's 23rd December.
23rd of December. But I was going to say that brings us to the hearing in January. Not quite, I'm afraid, because we now have to look at version 4 of the particulars of claim. And this is the version, as my Lord Justice Coulson observed earlier, which introduces the malicious prosecution claim. Version 4 is dated January 2020 and starts at page 100.
Yeah.
My lords will see the claim is more detailed than previous versions. In particular, a value totaling some £328,000 is placed on the claim. That's page 109. The date of this draft is the 6th of January 2020, but it is only ultimately a draft. It's common ground that the court never, quoting from Mr. Crossskell's skeleton in the appeal below, the court never issued this application and it was never adjudicated upon. So this is version 4, which never gets beyond draft stage. So just taking stock.
Was it sent to the defendant?
I believe it was.
Okay.
My lords, if the defendants say they got it, and I think they do, I'm certainly not going to dispute that.
All right. Because we're getting to the area of interest and
Yes, yes. So,
one or two questions which might arise.
yes. But as I say, taking stock, we've had the original version.
Can I just ask your learning friend, were you sent it? Did you have it?
As I understand, yes, it wasn't, not least it was in the hearing bundle that was prepared by
So
the claimants.
Okay.
In the hearing bundle.
Before Kirkconnell, which is the January 2020 hearing.
So it was in the bundle for the hearing in front
Yes.
of him. Right.
And what's not in our bundle is whether there was any response, or I may just have missed it, from your side about the appropriateness of amending to join the malicious prosecution claim in the absence of a letter before action or anything like that.
I don't think there was a response at that date. You'll see that in fact it's dated the 6th of January, that
Yes.
new claim form, etc. And either the 13th or the 12th of January. So it was in short succession. We went from one to the other. I don't think there was probably time, frankly, to deal with that before that hearing.
Sorry, what did you say about 13th of January?
The Kirkconnell hearing was either the 12th or the 13th of January,
Okay.
so it was within a week of that document being signed. I can't say obviously when it was actually served. We haven't got that much detail within the file.
Thank you.
It was on the 13th, it says, on page 110.
My lord, yes, and that's where I was going next, and you'll see the order made by District Judge Kirkconnell on the 13th of January. In the recital, he determines that...
Could you give the page number? So sorry.
110 supplementary.
Thank you.
And this is the 13th of January, is it?
It is.
Yeah.
So in the recital, he determines the claimant's claim is now reduced to a sum of £6,000. Paragraph 1, he refuses an application made by the claimants for an adjournment. So prior to this hearing, but following the successful appeal at the Crown Court, the claimants had applied to adjourn this case management hearing, but at the hearing, the district judge refuses that. Reallocates to the small claims track paragraph 2, and then enters judgment in default on the counterclaim for the full sum claimed, and that's paragraph 4.
So which, I'm sorry to be so slow, but the third paragraph of the recitals, upon the court determining that the claimant's claim is reduced to 6475, which version, the particulars of claim having quantified at 443,525, what's that referring to?
Well,
Which page is that referring
My
to?
lord, it must be the 7th of November 2018 version, what I call version 2, which was the version District Judge Sparrow gave permission for, because no permission has been given for any other version.
And the paragraph 14, which is the effectively the goods, isn't it? Yes, the goods, that's already been deleted.
Yes, by Deputy District Judge Collins, yes.
So these figures come from the claimant? Because they're not pleaded, I don't think, are they?
My lord, the figure of 43,000 for the trespass to goods claim appears somewhere. I think it's possibly in one of the draft versions, and
Okay.
I apprehend that what the learned Deputy District Judge was doing here was saying, well, you have at some point valued your trespass to goods claim at 43,000. The original claim form was limited to value of 50,000. So I'm because your paragraph 14 has been knocked out at a previous hearing, I'm subtracting one from the other, and I'm leaving you with claim for some £6,000 odd. To cut.
So he's taken the 50,000 limit,
Yes,
knocked off the 43,000 because it comes from somewhere,
yes,
and that's what he's left with.
yes.
Rather bizarrely, the 43,000 is on page 109, which is the version 4, which includes the malicious prosecution claim. If that's where he took it from, then he did have this document before him.
Well, my lords, to cut to the chase, subsequently, His Honour Judge Park's Casey determined that the decision of Deputy District Judge Kirkconnell to reduce the claim was plainly mistaken, and to enter judgment in default was plainly wrong.
But is my lord right that the figure of 43,525 comes from page 109.
It's certainly on page 109.
Yeah, but that's slightly different.
My lord,
I thought, sorry, I had noted down, I thought it was agreed that the claim that included the malicious prosecution claim, the one at 100 to 109, was included in the bundle in front of DJ Kirkconnell.
That was my understanding, yes.
Yeah, I was going to say, I wrote that down from
Yes.
what you said, so at least my note taking's all right this morning.
My lord, it is.
So on that basis, he could have taken it from there because that was before him.
yes, and just looking through.
But it's then baffling because he's allocating it to the small claims track, even though he's got a document that shows that the claim is 300 and something thousand pounds.
So he doesn't deal with an application to amend in terms at all. So presumably there wasn't a formal application to amend before.
My lord, I think that must be right. So, doing the best one can, he certainly had a document before him which quantified the trespass to goods claim at 43,000, and that may well have been version 4. But he certainly didn't consider that there was a formal application for him to amend in accordance with version 4.
A very odd thing to do if you appreciate that there's floating around, whether formally applied for or not, a suggestion that the claim might be worth upwards of 300,000, to send it off to the small claims track and say it's only worth 6,000. Anyway, but that's what he did.
My lord, yes.
And Mrs. Strafford, you said that Judge Parks later said that he'd been wrong in respect of the deduction and wrong to enter judgment. And the page reference for that?
His Honour Judge Parks' judgment is at page 128. So just to put this in context, if I may, my lord, appeal lodged against that decision of District Judge Kirkconnell, permission given for the appeal to renewed oral hearing. After the renewed oral hearing, the defendants effectively conceded the appeal. So the appeal was granted by consent, and that's the order of His Honour Judge Berkley on the 30th of June 2020 at page 118. But what the parties hadn't agreed about was consequential orders, in particular costs. So His Honour Judge Berkley directed that the appeal hearing, which had already been listed for the end of July, should go ahead to deal with those matters, the consequential matters. And there was a hearing on the 29th of July before His Honour Judge Parks, KC, and His Honour gave a reserved judgment on the page reference I just gave you, page 128, on the 6th of August.
So at 118, Judge Berkley allowed an appeal against the order of DDJ Kirkconnell.
Yes,
All of it.
it would appear so.
But then they don't agree consequential costs. And so that's then Judge Berkley,
Judge Parks.
sorry, Judge Parks, you're quite right, Judge Parks, and that's the judgment at 128 to 136, I believe. No?
And
140.
And the references to plainly wrong and plainly mistaken, my lord, are paragraphs 43 and 44 on page 136. My lords, just catching up where we are with the pleadings, if I may. So we've seen 4 versions.
But, and so just pausing there, none of that was the claimant's fault.
That's a submission I make in my skeleton, my lord.
But on the face of it, it can't be. A lot of this is the court's fault.
Well, the court being unaware either that the defence to the counterclaim had been submitted or being unaware of the consequences of that fact.
I believe it's the latter, my lord, but
All right.
We're plumbing the time of COVID now, aren't we?
yeah. So, my lord, catching up, as I say, with the pleadings, we had version 1, which was the original claim form. We had version 2, which permission was given by District Judge Sparrow. We've had versions 3 and 4, which don't appear to have ever been considered by the court on an application to amend, version 4 being the one with the malicious prosecution claim in.
The difference is that version 4 was in a bundle and potentially was referred to by DJ Kirkconnell.
Yes.
Yeah.
And now
we're coming to version 5.
And now we're coming to version 5, which is on page 120 of the same bundle.
Right, can I put in a question in advance so that you know I would like you to deal with it?
My lord, yes.
Before the 8th of July, there was a letter before action on the 15th of May 2020 in a response to it, which needs to be fitted into the chronology. And my concern is that there must be a reason why, having put out the 6th of January version of the particulars of claim, which included the malicious prosecution claim, your client then switched tack and issued a letter for action which was out and about before we get to DJ Stewart. And I think I've seen somewhere that he took legal advice at some stage.
Yes.
And the answer may be, if you're permitted to give it, if you're able to give it, that he was advised that since he was introducing a malicious prosecution claim, he should follow a pre-action protocol and write a letter before action. But at the moment, so as far as I'm concerned, there is no explanation at all for this apparent switch, which, as it looks to me at the moment, may be critical.
Well, my lord, let me deal with that then. And I don't seek to go behind the evidence that's before this court, and indeed was before the courts below. So it logically...
If you can take us to evidence which explains what was going on, I'd be very grateful.
Yes, I shall endeavour to do so, my lord. So
Thank you.
can I start with the letter before action then? Yeah. So that's at page 114. It's the 15th of May 2020.
So page 114.
114, yes.
Yeah.
Supplementary bundle. And we only really need to look at the opening paragraph and the final paragraph I'd like to inform you we should be taking out a civil claim for malicious prosecution, as the court appreciates, the point being the convictions have now been overturned and it's common ground that the cause of action could only have arisen once the convictions were overturned. And then the final paragraph, if I do not hear from you, I shall have no other option but to take out a claim against you for malicious prosecutions, which claim is separate from any ongoing claims between us. So, my Lord, Lord Mr. Stuart-Smith is right in that in January, claimant's position, as evinced by the draft version of the particulars of claim, was I'm going to stick the malicious prosecution claim together with my extant claim. Position in May appears to have become, no, I'm going to pursue them separately, and that point is reinforced when we look at version 5 of the particulars of claim, because by the 8th of July 2020, when they are drafted, the malicious prosecution claim has once again disappeared, but what has been reintroduced is the allegation of harassment, the claim to trespass to goods, and also we have a new claim for unlawful eviction.
Was there any evidence before the court below? Is there any evidence before us to explain this switch of tack?
My Lord, it comes in the witness statement of the claimant for the strikeout hearing before Deputy District Judge Payne. And, my Lord, give me a moment and I'll find the reference.
Is it page? The witness statement's at 98.
I believe it's later on, and I'm afraid I've lost the...
237.
It's 240.
Thank you.
Supplementary bundle.
Speaking for myself, I've not read this, so if we could help us.
Yes. So this is first claimant's witness statement filed in response to the application to strike out for abuse. So it was before Deputy District Judge Payne. And the material part is on page 240. And it's really letters F to I going over to page 241. I'm sorry, my lords, I think we should also look at little d as well.
I was going to say, it starts at D, doesn't it? Well, C is the way you've taken us to the Kirkconnell, which of course the appeal against the entire order apparently allowed by consent. And then D, legal advice.
And JO27 is the new action alleging malicious prosecution, as opposed to 286, which is what everything's been rumbling around before.
Yeah. Can you just remind me the date of issue of JO27? Is it the 8th? It's 14th of October. I'm sorry, it's 8th of October
2020.
2020, and it's page 167 of the core bundle. The core bundle.
Thank you.
So therefore, we now have version 5, and that bears the date. The draft bears the date 8th of July 2020. The hearing before His Honour Judge Parkes was on the 29th of July 2020.
Version 5, did you say?
Version 5.
And that was page, you gave us the page reference.
120.
120, yes, I got
Supplementary
that one.
bundle.
So this is then the version before Judge.
Well, I paused there. Judge Parkes was aware of it, or became aware of it, I should say. So he wasn't aware of it at the hearing on the 29th of July. He makes a complaint in his written judgment that the court hadn't given him the court file. He says, it appears it was hoped I could deal with this amendment at the hearing, but I didn't know about it. I've only just found out about it between the hearing and me writing this judgment, so it will have to go to the district judge in Southampton to deal with as an application to amend. But in fact, that doesn't delay us terribly, because His Honour Judge Parkes' judgment on the consequentials of the appeal was the 6th of August 2020, that's page 128, we looked at that. And then the hearing before District Judge Stewart was on 6 days later, on the 12th of August 2020, and his order is at page 141.
Yeah.
So, my lords, obviously now we're getting into the meat and drink of it, because the hearing before District Judge Stewart is of some considerable importance in this case. It was a telephone hearing. It was attended by the first claimant, who represented himself, and the second claimant, and it was attended for the defendants by solicitors and counsel. After hearing argument, the learned district judge was persuaded to give permission for version, what I've been calling version 5. And he made consequential orders as well, which I don't think it's necessary to dwell on. Now, what we know about this hearing is that the recording of it failed, and so there's no official transcript, but at a subsequent stage, I'm not sure when, a note was prepared firstly in manuscript and then in typewritten form by the solicitor representing the defendants. And that note you'll find at page 214, so just after, I'm sorry, page 143. So just after the order of District Judge Stewart. And after this typewritten note was prepared, it was prepared, of course, for the strikeout application, which was heard exactly a year later. After this note was prepared, it was sent to the claimants, and the claimants, the first claimant in any rate, commented on it, largely agreed the contents of the note, but disagreed with some parts of it. So perhaps, my lords, I can take you through those parts which were not accepted. Paragraph 3, well, 1 to 3, in fact, was agreed. The first claimant disagreed with paragraph 4, and in particular, he disagreed that he said this is the claimant's final argument. Paragraphs 5 and 6 are agreed, subject to this point. The first claimant says that District Judge Stewart stated at the hearing that there could not be any order stopping the claimants from bringing a legitimate claim in the future that would be an infringement of the claimant's right of access to the court. He disagrees with paragraph 7 to the extent that he disagrees that his explanation was unclear. He says he gave an explanation related to the resolution of the criminal proceedings.
Well, what have they got to do with it? If, as I understand your case to be, the first claimant was always just talking about the trespass claim,
Yes.
what's that got to do? What's the conviction got to do with it?
Well, I accept the force of my lord's point. I'm not saying that explanation was necessarily right or wrong, and I'm simply saying that was his comment on the solicitor's note.
Okay.
I mean, do we really need to go through this paragraph by paragraph? I mean, the issue between you is effectively whatever was said in relation to the suggestion from the claimants that this was it, as it were. The claimants say they were talking about the trespass claim. That's their case. The defendant's case is they thought it was everything.
Yes, that's
And
it.
so that's the point between you, and that remains the point between you, whatever the precise difference is on the words, isn't it?
My lord, that's right, and that's
because it's common ground that a certain amount of this is it, or agreeing to things being it, the last go, as it were said.
Yes. As I say, the note is largely agreed.
Yeah.
The explanation given, and my lord has it in a nutshell, which was given by the first claimant in the same witness statement we looked at a moment or two ago, paragraphs 46 and 47 on page 249 is, well, I was giving my answers in the context of the claim that was before the court, which was the trespass claim. And any comments should be seen in that context.
So that's the point of difference.
And what I said to the court was that I'm not going to make any further amendments. I didn't say to the court I'm not going to make any further claims.
Can we just, you've just referred us to paragraphs 46 and 47 on page 249.
I have, my lord.
Which, speaking for myself, I haven't looked at, so can I just quickly look at it? Yeah, thank you.
So just, and we're, as it were, nearly at the end of the chronology, we're nearly at the judgments below, but just taking stock at this moment, it seems to me the score is this, that by this stage, the claimants had made 6 applications which had been considered by the court. 4 of those were successful. That was the initial application, Deputy District Judge Andre, relating to amendment of the parties. The 2 applications to amend the pleadings, That's the one we've just been looking at in front of District Judge Stewart, and then the one very early on in the piece before District Judge Sparrow. And then another successful application was obviously the application for permission to appeal the order of Deputy District Judge Kirkconnell, which resulted in the appeal, which was again successful. So 4 successful applications.
And the first one you mentioned was to appeal the first successful application was which? There's 2 to amend, got that.
2 to amend.
Yeah. DJ Kirkconnell got that.
And changing parties, that was the very first case management hearing before Deputy District Judge Alexandra in November 2018, where I don't know whether it was as a result of a formal written application or an oral application, but the first 3 paragraphs of Deputy District Judge Alexandra's order was amendments to the names of the parties.
Okay.
And then the 2 unsuccessful ones were the application for specific disclosure. That was dealt with by a standalone hearing and was visited with an adverse costs order. And then the application to adjourn the hearing before Deputy District Judge Kirkconnell in January, which was dealt with by the District Judge at the hearing, was refused but didn't result in any adverse costs order.
No, but on one view, that was ultimately successful since the whole of that order was set aside.
Well, my lord.
Anyway, I got the point.
Yeah, well, my lord has the point that I mean, this is essentially, for the trespass claim, this is essentially it. There's no further applications by the claimants in the trespass claim. They've been successful on most of them, and the short point is this is not, I submit, death by 1,000 cuts.
What is the current status of the trespass claim? Pleadings have closed. Have there been any directions for anything else?
I had hoped the court was not going to ask me that. I don't. There was due to be.
It was due to be a CMC.
CCMC in April 21.
Yes.
But I think at the defendant's application, Mr. Coskill will correct me if I'm wrong, that was put off because by that stage we'd got the application to strike out the malicious prosecution claim. So as it were, everything seems to have been put on hold on the trespass claim.
So it's still, as it were, at a fairly early stage. There hasn't been any further CMCs. There's been no directions for trial, no witness statements, nothing like that.
No.
And one of DJ Stewart's orders had been that there should be a CMC or a hearing in December, which presumably would have been for giving directions, but that seems to have gone by the board as well.
My lord, I confess I don't recall that. I'm sure my lord is right.
The claim should, paragraph 5 on page 142. The claim should be listed for DJ Stewart for a case management conference with a time estimate of 90 minutes on the first available date after the 11th of December to consider directions as to disclosure, evidence, expert witness and directions to trial. And that did not happen.
I think that's probably the one that was listed in April 21.
Okay.
Which didn't happen because by that stage...
In March, the application struck out.
Yeah. So to take us to the application to strike out, I only need to say that, as mentioned already, on the 8th of October 2020, Claim 027, the malicious prosecution claim, is issued. It's right to point out, because I know it's a point relied on below and by my learned friend, that the date on the particulars of claim is the 14th of August 2020. So the malicious prosecution claim form, particulars of claim, is in the core bundle at 167. So I said it was issued on the 8th of October. The date of service is certainly endorsed on the claim form, and the date of service is the 13th of October. But if you go to the end of the particulars of claim, which are on page 176, you'll see that it was drafted on the 14th of August 2020, which was 2 days after the hearing before District Judge Stewart, which of course is consistent with the claimant's position from May 2020 onwards, being I am going to deal with malicious prosecution by way of a separate claim rather than by way of amendment to the trespass claim. And whilst we're at this point in the documents, the next document, page 177, is the defendant's defence to the malicious prosecution claim. And you'll see it's a full defence on the merits, but it also says at its start that the claimant's claim is an abuse and should be struck out, and it offends the rule in Henderson and Henderson. The short point I make about timing is that this defence is dated and presumably filed in November 2020. The application to strike out this claim was not made until the end of March 2021. So it was not made until after pleadings had closed. So
What was the date of the application? 30th
30th.
of March.
Is it?
I have it 31st of March,
Okay.
and I have the reference being page 76 of the supplementary bundle.
Okay.
In fact, if we look in the supplementary bundle at the order made on the 17th of May 2021, which is at page 208.
250.
208, my note is.
208.
208. So defendants now made an application to strike out. It seems that they make an application to obtain a transcript. I'm not sure why you would need to make a formal application. My experience is that that's always done administratively. But you'll note paragraph 5 of this order that further directions in respect of claim 027, that's the malicious prosecution claim, should be considered on the 12th of August. So that's the date on which Deputy District Judge Payne dealt with the application to strike out. So the short point I make about all of this is malicious prosecution claim issued in October, fully defended in November, application to strike out at the end of March 21, and then considered by District Judge Stewart in August 21. He had two options available to him. One was to say, well, the pleadings in the malicious prosecution claim and indeed the trespass claim are now complete, so I can just consolidate them together and give directions to bring them both onto trial. Or, of course, he had the option to accede to the defendant's application and strike out the malicious prosecution claim as an abuse, which is what he did.
Can you? Sorry, your reference to DJ Stewart
I think you mean
Is the
DDJ
8th
Payne, do you?
is the 8th of July 2020. We've passed DJ Stewart. Were you,
I'm
were
sorry.
you meaning to refer to DJ Payne
Payne, I'm sorry, my lord.
on
I
the
was.
12th of August 21?
I'm sorry, my lord, I was, yes.
That's okay.
And just before then we get to Deputy District Judge Payne's decision, I've tried to keep a running tally. I gave a tally of applications made by claimants early on. I think the application, the tally of applications made by the defendants at this stage is that they made an application to strike out the whole of the trespass claim. It was successful to the extent of 5 paragraphs, but not the whole of the claim. They made an application for a default judgment on the counterclaim, which was initially successful, but resulted in the appeal, which the claimants won. And then it appears there's also this application to obtain a transcript, which I'm not sure was strictly necessary, but there you are.
So it was not their fault that they couldn't get the transcript.
It certainly wasn't their fault they couldn't get the transcript.
And however you make it, it was an indication that it was a critical part of the defendant's application as to the what happened in front of DJ Stewart.
Yes, yes. So, my lords, we come to the 12th of August 2021, the hearing of the application to strike out the malicious prosecution claim before Deputy District Judge Payne. He gives an extempore judgment, and we have a transcript of that in the core bundle at page 119.
Yeah.
So there were 2 grounds relied on by the defendants. The first one was, well, no reasonable cause of action. That is not accepted by the learned Deputy District Judge, and we see that at paragraphs 4 and 5. He says he would be minded if that was the only issue.
Well, we've seen that. He says effectively it's arguable and there's no appeal from that. So the relevance is simply that he struck out a malicious prosecution claim that he found was arguable.
Yes. And then he deals with the abuse of process argument from paragraphs 6 onwards. He reminds himself of the rule in Henderson and Henderson. In fact, the quote at the top of page
Comes from the White Book.
Yes, and in fact, that's from Lord Bingham's judgment in Barrow and Bankside. He deals with the hearing before District Judge Stewart, paragraphs 7 and 8. In the middle of paragraph 8, he says this: I am quite sure that had Judge Stewart known that was going to be the subject of a further claim, albeit a different relief being claimed, I have no doubt he would not have granted the amendment that he did. At best, he would have allowed the claimant one last opportunity to amend his particulars of claim to include not only all the claim for damage and clarifying that, but also the issue of malicious prosecution.
What does that mean at best? Is that simply recognising that it was an order that would have been given to him? It's certainly not a finding or a conclusion about what District Judge Stewart would have done.
Well, my lord, if the point is that it's speculation on what District Judge Stewart would have done, I suppose that must be right.
But we're into that
Yes.
because we're interested in DDJ Payne's conclusion, because the hearing in front of Judge Berkley was an appeal. So whilst what he says is of interest and potentially importance, the real kernel of this is Deputy District Judge Payne's decision. Judge Berkley says, well, he would have refused the amendment, full stop, no explanation. He might well have refused the amendment if he'd known there was a malicious prosecution claim. But that was because, as DDJ Payne says, it was at least a possibility he would have given them one last chance.
Yes.
So DDJ Payne is saying, well, it's at least a possibility he'd have given them one last chance if he'd known.
And that, in fact, he appears to go slightly further on the next page in paragraph 11. And says, in effect, had the claimants come before District Judge Stewart in August 2020 saying, look, I've now been acquitted, can I amend my trespass claim to now include a malicious prosecution claim? The court would have said yes.
Is it common ground that, at least in theory, it was open to your client to bring the malicious prosecution claim either by way of amendment to the existing proceedings or by separate action? Is that common ground?
It must be, yes.
Thank you.
And my lord anticipates my point on this appeal, that the claimants had an option. They chose, as it were, option 2 rather than option 1, but that doesn't make option 2 an abuse. If Deputy District Judge Payne is saying, look, had you said to District Judge Stewart, I want to amend my claim to include malicious prosecution, and District Judge Stewart said, yes, that's fine, what is the effective difference between that and saying, well, I'm not going to amend because I have the right to bring a separate action for malicious prosecution. I've put the defendants on notice that that's the tack I intend to follow, and that's what I did in fact do.
But I think the respondent's case is that your client gave a binding assurance to the court that he was not going to pursue his malicious prosecution claim because it was not in the amendment that he was putting forward.
Well, I'm not sure if my learned friend does go that far. It may be that he does. That's where we're unfortunately in the territory of having to look at the solicitor's note and which parts of it are agreed and not agreed. But the claimant's position on that note is I never gave an assurance which went that far. I gave an assurance that I wasn't going to amend the trespass claim because the history of the trespass claim, of course, is important. I'd had a lot of it removed by Deputy District Judge Collins. I was now bringing a lot of it back in, but it was still the trespass claim. I was giving an assurance I wasn't going to amend that. I wasn't giving an assurance I wasn't going to bring a malicious prosecution claim. And in fact, the defendants knew full well I was because of the pre-action correspondence.
It wasn't you, Mr. Crosskull, in front of DJ Stewart, was it?
My lord, no. I only became involved in the one in front of Deputy District Judge Payne.
I mean, Mr. Stafford, just so that you know, I'm speaking for myself, I think my lord is right. I think that is the crux of it. Mr. Crossfell says at one point in his skeleton, your client made an election not to pursue the malicious prosecution claim in front of DJ Stewart. So that is the point that I think effectively is between you.
Yes.
And you say, I'm not sure he puts it that high. I agree that that is high. I think he has to put it that high in order for it to be an abuse.
If I can rise, I think since my learned friend, I think I have to put it that way because that has to, I think I said in my skeleton, that has to be our determination, our adjudication, and it's the representations he makes. I say he misled the court and thus the abuse flows.
Yes, but you do say he made an election.
Yes,
I mean,
obviously
and so that, I mean, that depending on how it falls out, is putting it quite high, but you accept you have to put it quite high for it to be an abuse.
Yes.
Or to be a Henderson and Henderson abuse.
Well, when I say it does fall within Henderson and Henderson, yes. I mean, it's the
But even if it didn't, you'd need to put it that high for it to be an abuse of any stamp.
it's for any of us to start obviously misleading the court, particularly when in this case, obviously it was a litigant after a long history, as we've already gone through today. And it is that representation, and I realise there's obviously a disagreement between us as to what was said now according to that note, but it's that representation that my clients stand by.
Yeah. Yeah, that's very helpful, Mr. Crosswell. Thank you. Yes, sorry, Mr. Shepherd.
Yes, well, I think then we can deal with the rest of this judgment and indeed His Honour Judge Berkley's judgment fairly quickly, but I do take the point in respect of paragraph 12 that surely that isn't what would have happened.
Well, I've written, if it helps, I've written by that no consolidation.
And I've written by it no managed together. So you can do either.
Well, the court has my point. Two claims that are in their infancy, which depend on exactly the same facts, overwhelmingly obvious. I respectfully submit that the appropriate course to take is to consolidate them. And that we will see. The point that District Judge Stewart made there was also a point that His Honour Judge Berkley relied on. His Honour Judge Berkley's judgment is at page 43 on the General Core Bundle, and I'll take the court through it relatively briefly.
Just before we get there, can I be sure I've understood what you've just said? Your submission is that it was, and you said this, and I think it is, common ground, that in theory, somebody who has two claims, and one of them's already on foot, can either apply to amend to put the second claim into the same proceedings as the first claim, or issue separate proceedings. But that's a question of issuing, it's not a question of trial, because you're not suggesting that it would make sense to try the two claims separately.
No, absolutely not. Absolutely not.
So issuing the second claim is not, I want this dealt with separately, it's that I want to keep it separate for pleading purposes, but trial I accept. The only sensible thing to do is to have it tried together.
Yes. And we know from Deputy District Judge Murphy's order in May of 21 that was, as it were, an option on the table for Deputy District Judge Payne at the August hearing, not an option he chose to take. But
in which case, I have not understood what the practical advantage to the claimant is. Issuing separate proceedings rather than amending to bring the claim into the existing proceedings. One would have thought he simply pays more by way of court fees and has to duplicate pleadings. What's the thinking behind it being a sensible way to manage litigation, to issue a second claim? I understand entirely you say he had a right to do it, that's an access to justice point. And why would one do that in preference?
Well, I think my lord's inviting me to speculate because I've taken the court to what the evidence is, which was
I understand the evidence,
but
I don't understand the thinking.
Well,
if
issuing a claim involves no exercise of discretion of the court.
I see. So you can do it as of right.
It's an administrative matter.
There's the other
Persuading the court to amend a claim is an exercise of discretion. It's if both options are legitimately open to you, and I say they were, you might realistically have taken the view much better to issue separately rather than go and chance my arm before a district judge who might not be happy about me amending to include a malicious prosecution claim. And although I take the point that you therefore incur the issue fee, what in fact happens here in this case, and we must surely proceed on the basis of what has actually happened, is that defendant doesn't immediately say, I'm not going to defend this claim, I'm going to make an application to strike you out. Defendant does in fact defend the claim, pleadings are closed.
Yes, but defends the claim expressly without prejudice to
Yes.
the contention it's an abuse.
Yes, but if it isn't an abuse, we've got a fully pleaded particulars of claim, we've got a fully pleaded defence, and we're ready to get in the car and set off.
One could see why they plead it out fully, because they hope that will influence the court when they come to consider the abuse thing, to think this is a rubbish claim anyway.
Yeah.
There is a sort of logic about your client's decision to issue separate proceedings, in addition to what you've just identified with my lord, which is that if you're confronted by a determined opponent, as clearly the parties were entrenched here, there is something to be said for saying, well, actually, I'd better do a letter before action and go through the protocol rather than simply popping up with a proposed amendment and have someone say, well, you haven't raised this properly, you should have complied with the pre-action protocol, so on and so forth. So it sort of fits if you do that, although, of course, you could, after a letter before action such as that, bring it in by way of amendment, technically.
Yes.
But your submission, I think, is that they've set themselves on the course of making it a separate claim.
Yes, and that is probably reflected in the paragraph in the first claimant's witness statement that we looked at on page 240, little f, where he says, I didn't want to obscure the issues in the existing claim.
Yeah.
It's effectively, I thought this was a neater way of going about it.
Yeah.
Yes, although since you said, and I understand entirely why you've said this, you never intended there to be two separate trials, so there will always be one trial, whether there'll be a formal consolidation or, as my lord says, simply the two cases tried together. In practice, they're not going to be two entirely separate sets of proceedings. They're going to be brought together for the purposes of trial, and that's the only sensible thing you can do. Nobody could view with equanimity what District Judge Payne refers to in paragraph 12, trial dealing with essentially the same facts twice. But that wasn't what you were trying to do. At any rate, that's your submission.
I'm sorry.
That wasn't what you were hoping to achieve, two separate trials.
Oh no.
No.
I'm. My lord, can I put it this way? I'm not sure I can get in the mind of the claimants, but I think I can safely say that nobody in their right mind would have hoped to achieve two separate trials, and the court certainly wouldn't have allowed it in any event. I think we're on the judgment of His Honour Judge Berkley at page 43 of the court.
Thank you.
And first 10 paragraphs or so, he sets out the background leading up to the hearing before District Judge Stewart.
Well, we've read it, so just do take us just to anything that you particularly want for us to, because we have read it.
I'll move on straight to his discussion and conclusion, which starts
Paragraph
paragraph
54, page
54.
60, yeah.
Yes. So if one reads 55 through to 58, he accepts that the rule in Henderson and Henderson is engaged here, even though it's concurrent proceedings rather than sequential proceedings, or even a later stage in the same proceedings. And the short point I take on this appeal is, as I said at the outset, that the rule surely only applies if a decision has or could already have been made. And the point about concurrent proceedings is that no decision has or could have been made in those proceedings. He refers to the White Book note, and we have all the authorities that are referred to in that note in the authorities bundle. I'll come to the authorities shortly, but I say they support the formulation that I've just given. 59 to 60.
Sorry, the formulation is ruling Henderson and Henderson only applies if the decision in the first set of proceedings has already been made or could have been made. What do you mean by the latter bit? Have I got the formulation, your formulation right?
Yes. So
what do you mean by the second bit? I understand.
The could have bit is I could have brought my claim. I chose to keep my powder dry, waited till the first claim concluded, and then brought a second claim.
And that's
So
either so-called res judicata, or it may be based on oppressive and vexatious and repeating and harassing your opponent.
Well,
on a wider interpretation.
on a wider, as the rule in Henderson and Henderson is applied in the authorities, could have isn't enough. So we have a number of cases, Barrow and Bankside being one of them, where they could have brought the claim in the first proceedings, but there was a good reason for not doing so. So could have isn't enough. It should have. So it's could have and should have. But I say this is a case of hasn't and couldn't. Because there's been no determination about anything. And that's the point about the concurrency of proceedings rather than...
Is it as simple as this? That your submission is ruling Henderson and Henderson only is engaged once the first set of proceedings in which it suggested the second claim might have been brought, has resulted either in a determination of a claim or at least a settlement of the claim, because it's clear from the authorities that settlement is enough.
Yes.
Is that what?
It is.
That's what it comes to.
That's what it comes to, my lord. Yes. And it might, and as we know from the authorities referred to in the White Book note, 3.4.5, it might be a later stage of the same proceedings. So the earlier determination might be an interlocutory determination, summary judgment, for example. But the mischief of the rule is that you're doing something later, which you should have done earlier before the court had come to a decision on whatever the earlier thing was.
The mischief of the rule is you've had your first claim and it's finished.
Yes.
And now you're trying to bring another claim.
Yes.
Which, if you were going to do this at all, you should have done the first time round.
Yes.
And you say it doesn't apply if the first claim hasn't finished.
Yes.
That's what it comes to.
That's that.
If
in a nutshell.
If the trespass claim had gone through to a conclusion, to
Yes.
judgment on the merits, and then you tried to bring the malicious prosecution claim, then you'd be in straight Henderson territory.
Absolutely. Clearly an abuse, because the second court would be trying the same, hearing the same evidence, trying exactly the same factual nexus as the first court.
Can I just try you one other thing? If a claimant, this is not this case, if a claimant were to issue 4 identical claims for trespass,
Yes.
the court would without hesitation strike out 3 of them because it's oppressive, and in Lord Justice Popwell's phrase, it's the second underpinning element. But that's not Henderson and Henderson as such, is it? It's just a wider concept of abuse in the context of case management powers.
Yes. Well, yes.
You don't need to refer to Henderson for that, do you?
My lord, no, although the judges below did. But I accept my lord's point, although everything is of course fact specific. If the four claim claimant could satisfy the court there was some good reason, or could
Well, then it wouldn't be an abuse.
Quite difficult to think of one.
But- well, or could say, well, how about just having the one claim and I'll amend that to, and all those things could be visited in costs.
Can I
And that-
ask you this, which is perhaps more realistic than someone issuing 4 claims for the same cause of action? Suppose you're a landlord and every quarter £1,000 of rent falls due. You issue proceedings for £1,000 of rent. When the next tenant defaults on the next quarter's rent, instead of adding it into your existing proceedings, which haven't got to trial yet, you issue another claim form, and then another one in the next quarter, and another one in the next quarter, and so on. So the tenant has to deal with 4 separate claim forms, and the court has to process 4 separate claim forms. Now, technically, of course, each cause of action is separate because each gale of rent gives rise to a separate debt.
Yeah.
Is that something the court can do anything about? Is it simply confined to saying, well, if you want to do that, you're going to have to pay the costs? Or can it say, this is an abuse, the obviously sensible thing to do is bring it all in one claim?
My lord, the latter, because it would fall within. My lords will probably recall the 6-point summary by Lord Justice Clark in the Vleeland body case, which was referred to in the Oldie Stores case, and the last of those is, when you've gone through all the others, the last of those is, does the latter action involve unjust harassment or oppression? And there would certainly come a point, it may come with the second claim or the third or the fourth, but there would certainly come a point where the landlord's behaviour would be characterised in that manner.
Be oppressive, but that
Oppressive.
wouldn't. The first claim hasn't got to trial, which hasn't been determined in any way. So why would that be capable of being Henderson and Henderson abuse, and this, your case, not? See, what I expected you to say was, well, it might be an abuse, but it wouldn't be Henderson and Henderson abuse. It would be abuse of a different type.
Well, I'm happy to put it in that way, my lord. It's not something. It's not something I had thought of. It would, yes, it would certainly be for the landlord to explain.
It is something raised by your argument. Your argument is the judges below, both judges below, were wrong to characterise this as Henderson and Henderson abuse because that requires the first set of proceedings to have reached a conclusion.
Yes.
By determining adjudication or settlement.
Yes.
That's why I set up a counterexample where that wouldn't be the case, but it still looks abusive. And I, speaking for myself, think your instinct was probably right, that the court could say that's an abuse. But then the question is, how do you distinguish that case from yours?
You distinguish it in this way. So when the first action, the trespass action, was issued, the claimants didn't have a right, didn't have a cause of action.
That's true of the landlord with the rent, because each quarter's rent only falls due each successive quarter. Indeed, under the RSC, that used to be the case, you couldn't amend a claim form, a writ, to bring in a claim which where the cause of action has arisen since the writ. But that's gone under the CPR. There's no problem now with adding in claims which have arisen since the date of the claim form.
Yes, and I suppose the landlord could say, well, if you, tenant, are going to show that you're prepared to disregard the contract we have between us by failing to pay the rent every quarter, you can't cry foul when I issue a new claim every quarter.
Well, but the way it should work under the CPR is you have an early CMC where this prospect is raised and the court could, and I suspect would, direct that any further matters be dealt with by amendment. You've then got a clear decision binding on the both parties. And if then the landlord insists on issuing new claims, the tenant comes back and says, this is in breach of order, it's oppressive, it's abusive, blah, blah, blah. In either direct them at his cost to bring them in by way of amendment, or if he absolutely point blank refuses to, you could at that point say these subsequent actions are abusive and the court would refuse to deal with them, I would have thought. But you work it into a place which makes it abusive.
My lord, what in my experience I suspect a court would do was direct that prior to the final trial, the landlord produce a schedule listing everything that is being claimed to date of trial.
Something like that.
Something like that.
And you might make the landlord pay the costs of the extra costs incurred in having to plead to every claim.
Yes.
Sorry.
We were in His Honour Judge Berkley's judgment, paragraphs 59 and 60. So this is the point that the court has identified as a key issue already, whether District Judge Stewart was, if not deceived, clearly misled. And the court knows my position in respect of that. I do want to look at paragraph 61 of the judgment, because I say this is not quite the question to ask. What His Honour Judge Berkley asks here is, you can test it by saying, well, what would have happened if the claimants had filed an application to amend to now include the malicious prosecution claim 2 days after the hearing before District Judge Stewart? Well, that, of course, is not realistic. That's never going to happen. It's clear that the claimants considered that they had two options. Option number one, which they originally ran with, and this is the January 2020 version 4 of the particulars of claim, was to throw everything together. And then option 2, which they ultimately went with, was to go through the pre-action protocol and deal with the malicious prosecution claim separately. But had the claimants gone for option 1, they wouldn't have had an application to amend on the 12th of August and then made another application to amend on the 14th of August. They would have had it all dealt with as one application, as appeared to have been the intention in January.
Well, they'd have stuck with the 6th of January.
Yes, they'd have stuck with the 6th of January draft, which had already at least been in a court bundle, it appears.
And I think to be fair to Judge Berkley, he's positing what the court reaction would be if your client had in fact done that which he was not going to do.
Yes.
And you can understand but the answer to that question depends conclusively upon what happened before DJ Stewart on the 12th of August. If the proper interpretation of what happened on the 12th of August was, I'm not going to do anything else to my trespass claim, the response on the 14th of August might be different from if what was said on the 12th of August was, I'm not going to bring any other claims at all.
Yes, yes.
So that's where the rub is.
Yes. Well, the court knows my position. Yeah. The claimants had two options. They chose one of them. And it is wrong to say that one wouldn't have been an abuse, that is to apply to amend to include malicious prosecution, but the other, which is to deal with malicious prosecution claim separately, is an abuse.
Yes.
Sorry.
I was just going to say, and as my lord says, that all depends on whether it's properly found that the claimants made an election not to pursue the malicious prosecution claim on the 12th of August.
And of course, I not only rely on the witness evidence which was before Deputy District Judge Payne, which I've taken you to, but the very fact that the particulars of claim for the draft of the particulars of claim for the malicious prosecution was made on was dated the 14th of August, pretty clearly shows that that wasn't the claimant's intention. The claimants didn't have any intention on the 12th of August to abandon their malicious prosecution.
Unless he's behaving utterly abusively. It's the response you get to that.
Well,
Then you're in circles.
I accept there's an element of circularity about it.
It's right, isn't it, from a note of the hearing that neither side raised before District Judge Stewart the fact, which was known to both parties, that there had been a threat of a new claim for malicious prosecution. I mean, on the one hand, you didn't say, when District Judge Stewart said to you, is this your final version? You didn't say, well, it's the final version of the trespass claim, but I ought to make it clear that I also have another claim, but I'm going to bring that separately. But equally, defendants didn't say, you have threatened a malicious prosecution claim, do we take it you're abandoning it?
And the defendants were represented by solicitors and counsel, so my lord, I do make that point, yes.
But it's right, isn't it? There's just no reference to it by anybody in the note we have at the hearing.
As far as I can tell, my lord, there isn't, no.
Might have been a great deal simpler if somebody had mentioned it. You wouldn't be here, or might not be here.
Well, my lord, that's I think all I need to deal with in respect of His Honour Judge Berkley's judgment. I believe I can...
What about his statement? Paragraph number 59. The claimant secured permission by way, if not of deception, of a clear misleading of the court.
Well,
that's quite a serious finding by the judge, characterisation by the judge of what happened at the hearing of DDJ Stewart.
yes, but that, my lord, is because he then goes on to say in the next sentence, Mr. Orji repeatedly and positively led the court to believe and all but promised that this was the final version of the claim arising out of the events of 25th and 26th of March 2018. So he's based that on his reading of the note that somebody said, or the first claimant said, this is my final version of the claim arising out of the events of 25th and 26th of March. And the note doesn't say that.
So you say that he was wrong to characterise it as misleading or deceptive?
Well, he must be, because he interprets the note as saying something I say that it doesn't go that far.
Suppose he was right and that Dr. Orji had misled DJ Stewart into thinking that there wasn't going to be any other claim. Would that make a difference to the case?
Well, I hesitate to hide behind the argument. It's difficult to speculate on what didn't happen. I take what I perceive to be my lord's point, that it would put the claimants in a considerably worse position than they are.
But my lord's question is one for you to address directly. Yes, your position would be less meritorious, but what difference does it make to the ability or otherwise to bring a substantial malicious prosecution claim which is agreed to be arguable and is in time?
If the question is, what would be the practical consequence of a barefaced lie?
What would be the principled consequence of a barefaced lie?
Then it's difficult to see that there would be any practical consequence, because the claim The claimants would have said, we're not going to issue a malicious prosecution claim, but then issued a malicious prosecution claim. The court would still be seized of it. The defendants would have still defended it. And the court would then have to decide whether it was either going to strike it out or consolidate it so the two could be case managed together.
Well, then the argument that it's abusive, I suppose it had been in black and white terms, District Judge Stewart had said to your client, well, there's a malicious prosecution claim floating around. Are you going to bring that claim or not? And your client had said in black and white terms, no, I'm confining myself to the trespass claim. And then the next day issued a claim form for malicious prosecution. Then the argument that that's an abuse, because you're playing fast and loose with the court. You're telling the court one thing one day and then doing it precisely the opposite the next day. The argument that's an abuse is a much more attractive one, isn't it? That is effectively, as I understand it, what Mr. Crosscall was going to tell us.
Yes.
That you made an election. You had a choice whether to bring in the malicious prosecution claim or not, and you chose not to. And then you're stuck with that. That's effectively what he's saying.
Yes. And of course, I rely on the evidence, and this was the only evidence before the court about the claimant's thinking that wasn't in fact what had happened. But there we are, my lord.
Well, DDJ Payne did not make that finding. You've taken us to Judge Berkley, and my lord's asked you about Judge Berkley at 59, but I don't read DDJ Payne as putting anything you like as high, the lies or deception or whatever, however it's put.
Yeah.
Yeah, okay.
My lord, I don't believe I need to take the court through the authorities in any particular detail, because I suggest they're all pulling in one direction. I suggest what is clear from the authorities, and we've of course certainly touched on this already, is that it's not only an abuse where a determination has been made, but where it should have been made in earlier proceedings, that it's clear that that applies whether the determination was made in separate proceedings or at an earlier stage of the same proceedings, and equally clear that that applies if the early judgment was obtained on a summary basis. That's the case of Kensal and Corey. And as my Lord Justice Nugee said, it's clear that it applies whether the determination is by settlement rather than judicial decision. And in fact, for sake of completeness, it can even apply if the identity of the parties is not exactly the same, and that's the Oldie Stores case. But that leaves us with the position that there is no authority which shows that it applies where there hasn't yet been and can't yet have been any sort of determination or resolution of any proceedings or any part of the proceedings. And that is precisely the territory that we're in here. My Lords, I'm very happy to go through the authorities if it would assist, but I apprehend that it probably won't. And therefore I will skip straight over. This is really, we've been dealing with my first ground of appeal, which is that
just before we leave the authorities, you accept, I think, that you can have Henderson and Henderson abuse in the same set of proceedings.
Yes.
And you can have Henderson and Henderson abuse at the interlocutory stage. But you say that what distinguishes this case from those cases is that effectively there has been no determination against which the Henderson and Henderson rule can apply.
Yes, there's nothing for it to bite on.
And I should say, whether defensively or otherwise, since the passage from my judgment is identified in the White Book commentary that both judgments referred to in Seeley, I think it is,
Yes.
you say, which was a case, one set of proceedings, but the critical decision had already been decided by Mr. Justice Field, I think it was, and the Court of Appeal.
Yes. Yes.
It's authority for the proposition, I suppose, that you can have Henderson and Henderson abuse in the same set of proceedings, but you accept that, and that, I hope, is common sense.
Yes, and my lord, if I could just refer, my lord, to your own decision in that case. It's page 152 in the authorities bundle. But I think my lord makes the position abundantly clear towards the end of your lordship's judgment at paragraphs 106 to 108. So at 106, Lord Justice Coulson has said already that you've looked at the Court of Appeal's decision, this court's decision in Tanner and Orji, and that shows us that the fact that the decision has been made at an earlier stage in the same proceedings rather than separate proceedings matters really not one jot. But what my lord says in paragraphs 107 and 108 are that the mischief, if I can put it this way, is a party puts its case one way, loses, and then comes up with a different way of arguing it.
Yeah.
And that it will be, at the end of 108, plainly oppressive for a defendant to be vexed again on the same issue. And of course, the point I make in this case is the defendant has not yet been vexed on either issue because we have not reached certainly a trial or any determination, any substantive determination in respect of either of the causes of action or either of the claims, perhaps.
I think I'm being very stupid, so please could you help me? If Henderson and Henderson depends upon the previous making of a decision as between the parties of an issue, what's the difference between Henderson and Henderson and res judicata? Because I've always thought that Henderson and Henderson was wider than proper res judicata.
Well, I think the strict translation, if my Latin doesn't fail me, is a thing that has been decided. And what Henderson and Henderson says, and it also applies to a thing that should have been decided.
Okay, could
and should have.
But I think, if I remember rightly, you accepted earlier this morning that if the trespass claim had gone all the way through to trial and judgment, and then you'd started the malicious prosecution claim, the chance of that being struck out as Henderson and Henderson abuse would be very much stronger.
Yes. I think that,
on the basis that it would be seeking to bring in exactly the same factual situation and try it a second time, having lost the first time, or indeed even if having won the first, it doesn't matter whether you win or lose the first time. The fact is you're trying to have a second go at it.
Yeah.
Because it would fit the could and should.
It would.
It would fit within the could and should.
Yes, it would fit within could and should. Yeah.
Can I ask? Did the parties receive any communication about a case of mine called Wilson and McNamara?
My lord, we did, and my lord, I believe you make the same point.
I don't claim any great credit for it, but it did seem to be directly in the point.
My lord, I agree. It's paragraph, I think, 58. Well, 56 to 58 of Wilson and McNamara. And of course, the issue in that case was whether a particular issue of justification should have been raised in earlier proceedings.
Well, earlier stage in the same proceedings.
Earlier stage in the same proceedings where the matter had come on before you for trial of a preliminary issue, and then there was the referral to the European Court. And then, in light of the decision of the European Court, at that stage the joint trustees jump up and say, we now want to argue justification. And if I've understood my lord's judgment correctly, essentially my lord said that, sorry, you're too late, should have raised this before the trial on the preliminary issue, what you refer to as the main judgment. But the joint trustees were able to resist the Henderson and Henderson argument for the reasons my lord gives in the middle of paragraph 57 at the top on my photocopy of the report, referring to Henderson and Henderson. The foundation of the principle is that it applies where a given matter has become the subject of litigation in, and then these words are emphasised, and adjudication by a court of competent jurisdiction. And my lords, I hope I'm not being rude if I say I agree with your lordship that very much follows all the other authorities that we have in the bundle. And the key is that there has been an adjudication or could have been an adjudication. We go that far, but we don't go so far as to where there never could have been an adjudication.
And it highlights the fact-sensitive and nature of the Henderson doctrine, and also the importance of the words "and should."
Yes.
Because if, for example, in a supremely efficient system, your client had won the trespass claim before being acquitted by the Crown Court, if one can conceive of that, Henderson and Henderson wouldn't, well, it would at least be arguable that Henderson and Henderson would not preclude him from bringing the malicious prosecution claim.
It would be arguable, and that was a similar argument to that which was run successfully in Aldi Stores and Barrow and
Couldn't have done it
Bankside.
before.
Nobody is disputing you could have brought this before, but we're accepting that there is a good reason why you didn't. So even though we're going to have to try much of the same issues.
I think in my lord's example, you couldn't have done it because, as we discussed much earlier this morning, the cause of action for malicious prosecution is not complete until the acquittal. And if you'd got to trial of the trespass claim while your appeal against the convictions was still outstanding, you wouldn't have a cause of action, so you couldn't have brought it in.
Well, arguing perhaps against my own position, there might have been an onus on me to say I have a live appeal here.
Yes.
So despite your efficiency, please don't try.
But you then, I mean, it does sort of illustrate another point which was discussed earlier, which is that what should happen is the court should be kept apprised of developments like this, and everybody should be open and transparent and put their cards on the table, and the court can decide. And it might have decided, well, the trespass claim is ready to hear, we'll hear it tomorrow. Might have decided, you've got an outstanding appeal, we'll wait to see what happens to the appeal, because it makes sense, if you're successful, that matters be heard together.
Yes, and of course, the court should be apprised of point was made in Aldi Stores, and it was also made in Stewart and Goldberg Lynn. But what I say, those cases were clearly saying is you can't keep your powder dry till the end of the first proceedings, not tell us about it and then start the second proceedings, because it obviates the opportunity for the court to case manage both together. This is a whole different ball game, because the court were apprised of the malicious prosecution claim by the very fact it was issued, while the other claim was still extant. So the opportunity for the court to case manage both was not denied to the court.
The previous order said the 12th of August will be used for directions. So if, for example, you had resisted, if the strikeout had been successfully resisted, the court could then have gone on and just said, right, okay, we'll and give directions.
Yes. And as I think we discussed earlier, the suggestion that the court would have case managed these cases to have two separate trials and two separate is not realistic. My lords, that all really is my first ground of appeal. If that were unsuccessful, I want to say a word or two about my second ground of appeal, and I do so by reference to my skeletons from paragraphs 26 onwards. And I appreciate there is something of an overlap between ground 1 and ground 2. But I start by making the point that Lord Justice May did in Manson and Holt, which was quoted in the Johnson and Gore-Wood. The court has to balance a plaintiff's right to bring before the court genuine and legitimate claims with the defendant's right to be protected from being harassed by multiple proceedings where one should have sufficed. And there are similar dicta from Lord Millett in Johnson itself. It's one thing to refuse to allow a party to relitigate a question that has already been decided, quite another to deny the opportunity of litigating a question for the first time, which has not previously been adjudicated on. And so I say in paragraph 26 that the bar is set high for deciding an otherwise legitimate claim should be struck out as an abuse of process. I've referred already to Lord Clarke's 6 points, which were quoted by this court in the Oldie Stores case, which I set out at paragraph 27. And even if the first 5 are met, we go on to the 6th, which is that the court will rarely find a later action is an abuse unless it involves unjust harassment and oppression. And then what I do in my skeleton is to go on and try and analyse the state of what had happened in the trespass claim, not of course the malicious prosecution claim, but in the trespass claim, whilst I would have to accept that you couldn't say the litigation had been conducted with rigorous efficiency, what I say is that can't all be laid at the door of the claimants. And in fact, if one analyses it, I say the position is really this, that very few of the delays in the trespass claim can be laid at the doors of the claimants. The chronology, very briefly, is this.
You've taken us through that. You say the bulk of the delays are actually down to the defendants, and some of the delays are down to the court.
Yes.
And you accept there are some delays for which the claimants are responsible.
Yes, and if I could just tell my lord which those are. So nothing up to the first case management hearing in November. That's just waiting for the court to list it. But at the first case management hearing, claimant was given permission to make an application for an amendment, which was then, that was in November, and the application was dealt with in November. So you've got a period of about a month and a half, 2 months there, which I accept claimant's fault, but that application dealt with fairly quickly. And then there is an unsuccessful, later on there's that unsuccessful application for specific disclosure. So that was an application made in March 19 and dealt with in April 19. So another delay of about a month, which you can lay at the claimant's door. But then what happens from April 19 onwards is the whole thing gets derailed by defendant's application to strike out and for judgment in default on the counterclaim. And all of that process is not ultimately resolved until the hearing before His Honour Judge Parkes, KC, at the end of July 2020. There were other things going on in the background between April 19 and July 2020, but none of that period, all of that period, I say, certainly not claimant's fault. And then it's only 6 days between His Honour Judge Parkes, KC's judgment about the consequential orders for the appeal and the hearing before District Judge Stewart that we've discussed in some detail. And then, of course, that effectively stops the clock, certainly so far as the trespass claim is concerned. So it's for those reasons that I say His Honour Judge Berkley was wrong I'm sorry, Deputy District Judge Payne, although His Honour Judge Berkley agreed with this, was wrong to characterise the lamentably slow progress as being largely attributable to the claimant. And I think, in fact, His Honour Judge Berkley went somewhat further because he accepted my learned friend's characterisation of the claimant's case management as chaotic, expensive and time-wasting and death by 1,000 cuts. And what I say in my skeleton at paragraph 28 is properly, and I think that evocative phrase was one of my Lord Justice Coulson's. What I say at paragraph 28 of my skeleton is that that is not an apt characterisation of the claimant's conduct during the course of this litigation. But really the bigger point I make is this: well, even if it was, that might provide grounds to strike out the trespass claim. How on earth does it provide grounds to strike out the malicious prosecution claim?
You've got a long way to go, because the way you would do it is you have a final order and then you have an unless order and then you're out.
Yes.
But none of that was done.
Yeah. So running, if I may, with my Lord's point, nobody is suggesting, the defendants are not suggesting that the conduct in the trespass claim is sufficient to strike out the trespass claim. So how can it be sufficient grounds to say there's been unjust harassment and oppression, Lord Clerk's sixth point, in the malicious prosecution claim? My Lords, that's paragraph 28 of my skeleton, 28A of my skeleton. 28B deals with the interpretation we should put on the note of what was said in front of District Judge Stewart. We've already discussed that extensively, and the court knows I rely on the first claimant's evidence in respect of that. I do say, and this was a point made by Lord Justice Longmore in the Oldie case, and Oldie and Stuart and Goldberg Lind, as we've discussed in the cases, which say, you know, there really is an onus on parties to tell the court. And Lord Justice Longmore in the Oldie case said, actually, it was really more in the defendant's interest to tell the court that they were potentially going to be exposed to another claim. And I blame them more than I blame the claimant for not revealing that there was another claim in the offing when both parties knew there was a claim in the offing. And that I apprehend was the point my Lord Justice Nugee was making earlier when he said, well, actually, both parties could have told District Judge Stewart about the possibility of a malicious prosecution claim. And 28C, that's a point I dealt with when I was looking at the judgments of the court below. But it really boils down to this. As Deputy District Judge Payne said, if the claimants had gone before District Judge Stewart and said, we're going to go with our, as it were, fourth version of the claim, and we're going to include the malicious prosecution claim, Deputy District Judge Payne said District Judge Stewart would have allowed that amendment. So he would have allowed the malicious prosecution claim to be brought in by way of amendment. I say, what in substance is the difference between dealing with it that way and dealing with it by pre-action protocol and then issuing a separate claim? If permission would have been allowed to bring in the claim by amendment, then there can be no objection to the claim being brought in not by amendment but by issuing a separate claim shortly after. My Lords, those are the points that I make in my skeleton. I'm sure the court has my position in brief. The rule in Henderson and Henderson, I say, doesn't apply to these particular circumstances. There hasn't and couldn't have been point, and that therefore both of the judges below were wrong to consider that it could. When properly analysed, the claimant's conduct in the trespass claim was not unjust harassment or oppression which would justify striking out the trespass claim, and therefore certainly not unjust harassment or oppression which would justify striking out the malicious prosecution claim. And the final point, which we haven't touched upon yet, is this: whatever happens today, there will still be a trial of the trespass claim. So the claim for harassment, trespass to the person, trespass to the property, and unlawful eviction, the claims brought by the claimants, and indeed the counterclaims brought by the defendants. I don't think we've looked at one version. I'm not, but the amended after. I'm sorry, I should have explained the background to this. After District Judge Stewart allowed the amendment to the particulars of claim, version 5, there was then an amended defence and counterclaim. So the counterclaim now alleges, for example, assault by the claimants on the defendant. So all those issues are yet to be tried. And the issues raised on the malicious prosecution claim, in my submission, are entirely appropriate to be tried along with those because they are so intertwined with them. So we're going to have a trial on all those issues anyway, and that just reinforces, I say, my point that the order that Deputy District Judge Payne should have made was to consolidate and not to strike out. My Lords, unless I can assist on any particular matter.
Oh, one thing, because I'm sensitive about such things. Is your family name one word or two? Are you Mr. Granville Stamford?
Therein lies a tale.
Well, don't worry about the tale, but what's the answer?
Family name is Stafford, but there's another Andrew Stafford at the bar, and he was there first.
Okay, so
I've
Stafford.
added my surname in.
So in today's court, you're just Mr. Stafford.
My Lord, I'm usually Granville Stafford in the courts, but it matters not one jota, but I appreciate your, my Lord, asking.
Yes, Mr. Crossman.
Move along. I'm constrained by technology and the wire that's attached to my. My Lords, I will probably, I'm afraid, have to go back through some of the documents inevitably that we've looked at factually of this.
Please take your own course. We understand that when there are points of issue that arise out of a lengthy, if not to say convoluted, procedural history, counsel have to show us the bits they rely on in relation to that. So don't feel at all shy about doing that.
Well, as we're coming up to the shorter gem, there will be a bit I suspect I'll be able to cut out, having now obviously heard my own friends' submissions, and I've been trying to do so as we go. And I've also tried, obviously, when I've been called upon to interject, to sort of lay my cards on the table as well, because I think it does help you to know where you're going with this. I know you've got our skeleton arguments, but nevertheless, I think it's fair to say that the respondents rely upon that determination, or, my Lord, in your words, the adjudication that was made in the trespass claim. It is that order that was made by District Judge Stewart, i.e. the permission to amend, that being granted, but expressly, we would say, excluding further causes of action. Now therein lies the mischief. in my submission, there was a representation, an election not to pursue additional claims. And I will, in due course, and I think we will, I'm afraid, need to go back to look at that note, because so much turns on what was said at that hearing, and obviously it is a crying shame that technology, the recording failed us, but we're doing the best we can as ever.
Are you using election in a technical sense? And if so, after the short adjournment, would you tell me what that technical sense is?
His choice.
Does it add anything to?
No, it was his choice.
Okay, thank you.
Obviously, what I would say though is that there was that decision, that choice, not to pursue an additional claim. But as is highlighted particularly by HHJ Berkley, and say actually when you go back to Payne's judgment as well, there is certainly, if not a hint of saying a similar thing, there was dishonesty there. Not least because of the drafting of that new particulars of claim. The dates are no mere coincidence. The extent of that pleading, obviously it took another month to be actually issued, but one cannot ignore that it was signed 2 days after the hearing before District Judge Stewart.
So your allegation is he was dishonest?
I would suggest yes, that it's the underlying aspect.
What conceivable benefit? Or sorry, let me put it in less tendentious terms. Why would he be dishonest about something like this? If it was his intention to pursue the course that he'd set upon,
Yes.
which is letters for action leading to a separate action.
Frankly, I don't know is the answer to that. But it still comes back to the question as to why not say, I've already got this in motion. I do not want to deal with it before you.
But everybody knew he'd got it in motion.
They did, and when we come back to it, although nobody, as is properly pointed out, within the note that we have, there is no reference to anyone referring directly to the malicious prosecution claim. However, there is obviously repeated representations in relation to the criminal appeal, and also there's the reference to the £300,000 claim, that being the malicious prosecution.
Well, the criminal appeal is obviously is separate, but if there are other references that you say tie in, then you'll take us to those. But you can understand that the criminal appeal is nothing to the point, it's the malicious prosecution civil claim that matters. So you'll take us to that.
But it's the ending of that appeal, isn't it, of course, of the criminal appeal that is, that obviously then crystallised. And I must accept, of course, that the appellants could only have brought their claim for the malicious prosecution action post the determination of that appeal.
Yeah.
Must accept that. And I accept that, obviously, that was late 2019. So Kirkconnell, for instance, was the first opportunity they potentially could have pursued that matter. But certainly when it comes to that hearing for Stuart, yes, there's no direct reference within there, but of course we have the repeated reference to, are there going to be any more claim forms? And again, it's within a note, it's not within a recording. But when one goes through it, I would suggest it's indicative that this is something that was openly and actively put before District Judge Stewart. Obviously, this all arises, though, in connection with this, effectively, this incident over the weekend or the days of the 25th and the 26th of March. I should say that, to put a bit of context, this property is owned by some siblings. They're not professional landlords as such. The second respondent sits behind me as a social worker. His brother is a police officer, and I think his sister is a private client solicitor. And obviously, the problem seemed to have started with the appellants failing to pay their rent in full or on time. Ultimately, it was not their decision to bring the prosecution. That was obviously outside of their hands. It was Wessex CPS.
The police were called.
The police were called. That was their election to call the police.
I was going to say, I mean, that landlord and tenant disputes don't tend to involve the police. I know some do, but
Fortunately not.
and that was the defendant's choice.
Yes, And they,
And then
Signed
thereafter,
witness
once the
statements.
police are involved, thereafter it can be out of everybody's hands.
yes, but they must have signed witness, I've never seen them, but they must have signed witness statements with statements of truth, etc.
Yeah.
As I say, I wasn't involved at that stage.
Can I just be sure? You said ultimately it was the decision of the police to prosecute
CPS.
the CPS. You're not suggesting, are you, that that is a complete defence to the malicious prosecution?
There's authority on that is not a complete defence, but
That's
it's
rather-
nevertheless a relevant factor.
It's a relevant factor. I mean, if the truth is that your clients came up with a whole lot of lies in order to get the claimant arrested, and he was arrested on the basis of what they had told untruthfully to the police, one would have thought they could make themselves liable for malicious prosecution.
Yes, conceptually they can.
Yes.
Um,
And we're not, any more than the judges below are, being asked to form any view of the underlying merits of the claims, are we?
No, and of course beyond the pleadings, which you've had the pleasure of seeing as well, I'm none the wiser, frankly, and maybe the judgment of the recorder. But again, obviously in a different context.
The only judgment is it's arguable.
Yes.
Well, the very fact the magistrate's convicted but the Crown Court acquitted shows that there are two sides to the story.
Yes, and as you pointed out, my lord, earlier on, a different test. But obviously, what I would say in relation to the way that this has progressed, and I talk about just the way that this has gone from March 2018. It is a difficult process, which is, by the way it's been conducted, we would say by the claimants, by the appellants, has caused confusion. It's caused stress certainly to the respondents. As was accepted by His Honour Judge Parks, I think it was in his first or second paragraph, he says, well, these are serious allegations. And not least when you start to increase the value, the figure is effectively yo-yoed from, it started off at 50,000, went up to 323,000, and has come back down as it currently stands on the trespass claim at 95. But of course, these multiplicity of versions do add expense to a claim. The respondents, as is their choice, have instructed solicitors in an early stage. They had counsel. They are not represented by solicitors at the moment. I was instructed to attend that hearing in 21. By that point, solicitors have already come off the record, and they haven't had solicitors since. But prior to that,
Sorry to interrupt you, just on the multiplicity point, actually, unless I'm missing something, the trespass claim is relatively straightforward. And what seems to have happened is that the trespass to goods claim has come out because the defendants got it struck out and then was allowed back in by way of amendment. I mean, that's, I mean, when you dig right down to the jam in the middle of the donut, that appears, on the trespass claim,
yes.
that appears to be the main thing.
Yes.
I mean, it's all tinkering, really.
Well, there is certain, and a good example of that is the adding of parties and removal of parties that happens at the beginning. Of course, that all adds to delay. I mean, it's just not clear, for instance, and normally you do recitals, it's useful to actually tell people what's going on, because if you leave it blank, you don't know who's making an application. But certain parties are added. For instance, I think the first respondent to this appeal is added in, I think, before District Judge or Deputy Judge Alexandra. But there's no explanation as to how, in fact, he is added.
But in terms of the substance, okay, I get there were some changes to the parties early on, but in terms of that overall period of delay, for the trespass claim, the defendant sought to strike it all out. They struck out some bits of it, including the trespass to goods, which is the long list of items, and that came back in subsequently.
Yes.
You know,
I'm not necessarily sure how that got back in, but nevertheless it was allowed. But
well, it's not clear why it was struck out in the first place, and it's not clear why it came back in. those may be criticisms that could be levelled at the court, maybe, but it litigation, particularly litigation conducted by individuals, these sort of lacuna, I'm afraid, occur. Anyway.
Yes. Well, I think it's by that November we have our first proper separate particulars. First one being included within the claim form. I'm talking about 2018, and of course, my lord, you're correct. It's in early 2019 that first application comes to strike out, which clearly must have caused delay, and that is at the defendant's fault, if I can put it in those terms.
Yeah. Well, it's not a question
cannot
of fault.
It cannot be all laid at the door of the claimants, and I think my lord is your point.
Yeah.
Which I think must be a fair point. A bit like the erroneous decision of Kirkconnell. It clearly led to delay because I think the consent order is approved by Berkley in the June of 2020. Although matters clearly continue along that with regard to case management, because your own experience.
Not overly rapidly.
Well, whether that's it doesn't.
I mean, the length of time.
Yes.
Between the Kirkconnell decision and the Parks judgment is about 15 months, or to translate, the sort of time that one would expect most civil litigation to start and finish. And certainly in some parts of the courts in which I have had dealings, that was always our promise.
Certainly, yes. I mean, I have to say I can't remember quite what it was like then, but certainly I'm afraid you're looking at CCMCs often a year away now. But whether it was like that at that time, but it is an extended period of time. Again, we have no explanation as to whether it's because of the ongoing appeal, whether it's because of listing issues, or otherwise.
And
again,
we have to acknowledge that, as my lord had said earlier, that we are in peak COVID time for some of this. So
yes.
I get that. All right. Well, Mr. Crosscall, we'll stop there and come back at 2. Whilst I don't think there's any danger of it being trespassed, could I say that I have to rise at 4:20 because I'm so old I'm having a flu jab.
Court rise if able.